My name is Richard Wilner. I'm a co-founder of the immigration law firm of Wilner and O'Reilly, and I've been practicing U.S. immigration law exclusively since 1999. I've been board certified for over 2 decades as a specialist in U.S. immigration law by the State Bar of California's Bureau of Legal Specialization. Today, I'm going to break down one process for you, and that process is the H-1B visa. H-1B visas are done on a cyclical basis, or a yearly basis rather, and that yearly basis is according to the fiscal year. Right now we're talking about H-1B visas for fiscal year 2027, which begins October 1st of 2026. The H-1B visa is limited in terms of numbers. There are 65,000 visas available per year, an extra 20,000 visas if you've graduated from a U.S. university with a master's degree or higher. Most lawyers refer to the amount of H-1B visas available as a lottery process. That lottery ticket goes on sale, typically the beginning of March or the first 2 weeks of March, and it doesn't matter at what point in those first 2 weeks that you purchase a ticket. But it's not you, the employee, that purchases a ticket. It's your employer, or your potential employer if you're not already working there as a student who's work authorized. U.S. employers have the opportunity to purchase lottery tickets, as I mentioned, during the first 2 weeks of March. There's a ramp-up procedure in order to get that lottery ticket. That ramp-up requires company registration, and once that company is registered, they're able to submit information about their potential employee, including but not limited to the position that the individual is going to be working in. I'll come back to that later. If you have a successful, or if your employer has a successful or winning lottery ticket, your employer, as well as your employer's lawyers, will be notified at the end of March that they have a winning ticket. The government will then notify that the employer is able to file the case. Keep in mind, the employer is the petitioner, and the employee is referred to as the beneficiary. Along those lines, the United States government has predetermined that the U.S. employer is required to pay all legal fees and costs associated with the petition. End of March, the lottery is drawn. If the employer has a winning ticket, the employer will be told to file the case by a date certain in June. There's 2 ways to file the case: regular processing or premium processing. Premium processing bookends the process, and the government will notify us or take some form of adjudicative action within 15 business days of filing the application. It costs an extra almost $3,000 in filing fees to have the case premium processed. If you do it according to normal processing times, it can take a number of months. In any event, you need a winning ticket in order to be able to file the case. H-1Bs are not available for every type of position. Instead, the government, the Department of Labor specifically, has preordained which positions qualify. The Immigration and Nationality Act has specified that H-1Bs must be for specialty occupations. And in plain English, specialty occupation means that you have a bachelor's degree or higher, and that the position that you're going to be working in requires a bachelor's degree or higher. For example, if you have a bachelor's degree in culinary arts and you're working in as a head chef, that is not a bachelor's degree position. Think more along the lines of tech or operations or management and not arts. I'll come back to that either in this episode or a latter episode. If you have a winning ticket, as mentioned, you can file the case, or your employer can file the case. H-1B status, no matter when the case is filed and no matter when the case is approved, will not activate until October 1st, the beginning of the fiscal year. If you are here in the United States in status, which would typically mean that you've graduated from a school, a U.S. school, and you are doing your optional practical training and working in that OPT phase, if you're here in status, in either F1 student visas or H-1B already, you can file a change of status. If you are overseas, however, and need a visa label, and this is the first time H-1B, your employer according to new doctrine by the Trump administration, will be required to pay an extra $100,000 fee, which makes this process cost prohibitive for most employers. That $100,000 fee was recently upheld as legal by a United States District Court. Most of these cases will be filed for people who are already in the United States, maintaining their legal non-immigrant status, which, as mentioned, is typically F1 or already in H-1B. Again, if F1 and you have a qualifying petition, you are able to change status. That status takes effect on October 1st with no other changes needed. If you are H-1B, as soon as this case is filed, or as soon as a new case is filed, you can begin working for the new employer, whereas if you are a student, you have to wait until your case is approved. H-1Bs, there's a couple of different exceptions for the rule of the quota, or the lottery rather, and that's if you are a national of Chile or Singapore. There's two carve-outs for nationals of those countries. And while there are numerical limitations to those cases, those numerical limitations are never used up. More specifically, there's 10,000 H-1Bs available to Chileans and Singaporeans each year, and those cases can be filed at any time. There's one other exception worth mentioning, and this doesn't matter where you come from. There's a carve-out for traditional nonprofits. If you are working for what's called a Cap-Exempt employer, which is a nonprofit, or other employers who are affiliated with institutes of higher learning, think college or university, then you are not subject to the quota, and those cases can be filed at any time of year. H-1Bs are complicated. The law is complicated. Do not trust decisions on your future to people who dabble in it. Whether it's us or someone else, trust the decisions for yourself and your employer to people who specialize in this area. I hope you found this episode informative. Should you be in need of further information, please do not hesitate to reach out to us. Again, my name is Richard Wilner. The law firm is Wilner & O'Reilly. You can contact us online at wilneroreilly.com.